Hi, I'm Leanne Grindrod and I am currently working within the Commercial Technology and Media Unit here at Gately Legal. Our commercial team have industry-leading experience spanning the entire sports network. We have worked for football clubs, governing bodies, national sports organisations and leading sports brands. We advise on a number of things ranging from commercial agreements such as licensing and sponsorship, right through to advice on how best to protect and exploit your intellectual property rights. Today, the focus of this webinar is to provide you with a general update on the commercial impact of a no-deal Brexit. This webinar starts with the latest developments in Parliament, moving on to the financial impact of a no-deal Brexit commercially, the effect on your contracts, how to review your existing contracts and what to look for, how best to negotiate the future contracts, whether EU references in your contracts will cover the UK in a no-deal scenario, before ending with looking at any jurisdiction and dispute resolution clauses. As things stand, the UK is still set to leave the EU on the 31st of October 2019. However, the precise terms on which we will leave remain unclear. In particular, we do not know if there will be a deal or a no deal. Brexit poses some unique challenges for sport and recreation. At this moment, it is unclear what our future relationship with the EU will look like, but there is a possibility that the UK will exit the EU without a transition period with no deal. Such an outcome would present significant challenges for our members and many other businesses and organisations operating in this sector. In this short webinar, we will try to expand on some of the possible impacts that a no-deal Brexit may have on your commercial contracts, answer any questions and provide guidance as best we can on how to negotiate any future contracts. Doubt that Brexit will impact us financially. Leaving the EU without a deal could affect you commercially in a number of ways. Firstly, the exchange rates could fluctuate significantly, leading to a rise in the price of imported sporting goods. You should consider the effect that fluctuation of the pound will have and implement possible strategies to mitigate the currency violations such as hedging. Consider who would be responsible for any large fluctuation in currency under your contracts. Tariffs could be applied to goods and services provided to and from the EU following Brexit. There could be changes in tariff rates for trade with countries outside of the EU, which would decrease the profitability of your contract for the purchase of sports equipment and clothing from within the EU. Thirdly, these suppliers might also need to change the jurisdiction in which they source certain components of their products to comply with the rules of origin or face paying tariffs, adding expense to your contracts. Consider restructuring your supply chain to maximise tariff efficiencies or to use different goods or service suppliers that are less exposed to Brexit-related risks. In a no-deal Brexit, the UK will be considered a third country for customs purposes in the EU. Customs checks will be required for goods entering and leaving the EU, increasing costs and delays in connection with supply contracts. Not only could this make obtaining equipment required for a tournament or sporting event more difficult, it may take longer to receive the equipment, which will have a knock-on effect on lead times and price. Many businesses that you choose to work with may choose to relocate their operations to a country within the EU. Hosting sporting events in the UK, for example, will become more difficult. If the UK will no longer be automatically subject to the free movement rules, the additional cost and administrative burden associated with the movement of those individuals and equipment in and out of the UK might be problematic. The UK and sport and recreation sector currently benefit from EU funding from a number of different sources. The most obvious example is the Erasmus Plus programme. It provides funding for education, training, youth and volunteering projects and is a huge benefit to the sports sector in general. We don't quite know what is going to happen with this funding if we have a no-deal Brexit, but the chances are we won't be able to access the funding once we leave the EU. On the plus side, all existing Erasmus projects will continue to be funded as long as you received approval prior to the exit date. Please be wary that this only applies to UK organisations, so if you have partnered up with any non-UK business or other organisation, this guarantee will not apply to those organisations. Now, many of you will be questioning whether Brexit could be a ground for termination of a contract. Brexit as a concept could fit into the ambit of various legal concepts known as force majeure, material adverse change, or frustration. I will briefly discuss each of them in turn. Starting with force majeure clauses, the success of relying on this clause as a ground for termination will heavily depend upon the facts of the case and the wording of the agreement. If Brexit makes performance of the contract impossible, it may be a force majeure event. However, force majeure events do not normally encompass events which one party reasonably foresees will inevitably happen, so it is important for you to check the date of your contract, as this may be relevant when determining the application of such clauses. Looking at material adverse change clauses, these are not included in all contracts, but it is worth checking your contracts for such a clause. These clauses are wider than a standard force majeure clause and could potentially be triggered by financial hardship suffered post-Brexit and may allow you to renegotiate your terms should the contract become unprofitable or subject to change in the law. Finally, parties could also try to argue that a contract has become frustrated as a result of Brexit. This essentially means that it has become impossible to perform certain obligations under a contract, but no one party is to blame. You need to be clear about the obligations that are no longer possible to perform. So you have checked your existing contracts for possible termination rights. You now need to review your contract further. The first thing to look at is a contractual term. Does this date run beyond the date of the proposed Brexit date? Does the nature of the contract mean that it crosses the UK-EU border in some way? Whether this is a sponsorship agreement, a management agreement, or a supply agreement, it is important for you to start to look at how this could affect your membership. For example, is there any interest in seeking early termination of an agreement? Are there any break clauses? Or is there a risk of the other party terminating before you? What about the things to think about in your existing contracts? But what can you do now to mitigate the risk or issues when entering into any new contracts? There are 4 key recommendations to think about going forwards. Firstly, you could look to include an express statement in all new contracts to confirm that the force and effect of the contract, or certain clauses within the contract, are not to be prejudiced or diminished by the UK leaving the EU. Perhaps adding express wording which addresses pricing mechanisms, pricing reviews, and the allocation of currency risk will reduce the chance of a dispute later down the line. You may also want to think about redefining the meaning of force majeure so that it encompasses certain Brexit-related events relevant to the subject matter of the contract. It would be good practice to address delays in the delivery of goods, such as sports equipment, due to cross-border issues and to prevent the risk of increased cost and possible payment penalties or termination for late delivery. Finally, as a precaution, where legislation is defined as being incorporated as amended from time to time, the contract should state that any changes that will have a material adverse effect on either party within the agreement are disregarded where possible. Those are the 4 key things we would recommend at this stage. Each case is different, and if you have any concerns or you need further assistance on these points, please seek legal advice. Given the UK has been a member of the EU for many decades, reference to the EU are part and parcel of commercial contracts. Does that mean your contracts that include references to the EU will continue to include the UK post-Brexit? Well, firstly, you need to look at the definition of territory within the contract. If it refers to member states, open speech marks, from time to time, close speech marks, then the UK will not be included post-Brexit. If there is a full list of countries named in the definition, and the UK is one of these countries, then the UK would still be covered by the contract after Brexit. So what about new contracts? If such contracts should always include the UK, then think about adding express wording to say that if and when the UK leaves the EU, then the relevant territory is automatically extended to include the UK along with the EU. It is sensible to plan ahead and draft the provision as open speech marks, the UK as it stands now, close speech marks, or open speech marks, UK as it changes from time to time, close speech marks. This would cover the situation where Scotland could try and seek independence in the future. It could introduce further complications to any disputes between parties where one remains in the EU and the other does not. Currently, the UK is subject to the Brussels regime's rules on determining jurisdiction for disputes, but one possible future effect of leaving the EU without a deal is that the rules will cease to apply to the UK. The UK and EU could enter into an agreement that mimics the approach under the Brussels regime, but this is not guaranteed. If you are a party to a current dispute which relates to the UK and another part of the EU, look at steps to resolve the dispute sooner. Look at maybe settling or look at alternative form of dispute resolution. If you have a judgment to enforce in another EU state, prioritise this action as soon as possible. In all new contracts, it is a good idea to include a non-exclusive jurisdiction clause in respect of the UK courts, or choose exclusive jurisdiction of any other appropriate member state. Arbitration will not be affected by Brexit, so therefore this may be a better method of dispute resolution. Each organisation has its own requirements. If you need any tailored legal advice or have any other concerns, please contact a member of the commercial team at Gately Legal. For ease of reference, we've included John Burns' contact details to this slide, who is a partner up in Manchester in the commercial team. To go along with this webinar, we have a fact sheet covering the key points. These are accessible alongside these webinars on the SRA website.